The topic that we will be discussing is the next decade of innovation, how the government is using patents to shape the future. I have to be honest with you, I've been practicing patent law for over 20 years, and reading Professor Minnell's paper and thinking about the topics that we're talking about today really expanded my horizon. And I really look forward to the future where we will put more focus on this topic and put it to practical use. Allow me to introduce our speakers, distinguished speakers today on this panel. First is, of course, Hope Shimabuku. She is the director of the Texas Regional United States Patent and Trademark Office, and she assumed this position in January. And since then, she's been on a whirlwind, traveling and doing outreach and doing a fantastic job. Prior to this position, she was the VP and corporate counsel at Xerox, and she also spent some time with BlackBerry. As an engineer, she worked at Procter & Gamble and Dell. So I'm not going to go, and another thing I want to mention is that she currently serves as the chair of the State Bar of Texas Intellectual Property Section. And I could go on and on about Hope. I've known her for a long, long time, but let's not spend too much time on the intros. My next speaker is Judge Stacy White. She is the administrative patent judge on PTAB in the in the Texas Regional Office. She started in this position 3 years now ago. And prior to this, she practiced patent law at Alston Bird as well as Jones Day. She also clerked for Judge Barbara Lynn while she was a law student. My third speaker is Mark Dvorak, and he is the lead IP counsel for NASA. So as the lead patent counsel, IP counsel, he oversaw all the IP matters and solicitations and prosecution, tech transfer for the agency. And I look forward to learning much, much more about Mark's everyday functions. Prior to NASA, he was the deputy chief counsel for IP at the Department of Energy. So without further ado, we will start with each speaker giving a brief remark, and then I will pose questions as well as open the panel up to questions from the audience.
Well, good morning. Can everybody hear me all right? I am, as she said, Judge Stacy White here with the PTAB out here in Dallas, and I congratulate all of you on being here bright and early. When I was a law student, you wouldn't have caught me here this early in the morning, so glad to see so many students out here. So we're going to talk a little bit briefly about the USPTO's role in social justice. And when we thought about social justice in the Patent Office, we thought of it as really a mechanism to provide access and opportunity to all the people that seek to use our services. And in the last few years, we have put in a lot of changes to expand access to the office and to provide more opportunities for people who are looking to patent their ideas. One of the first things we've done to expand access to the USPTO is our regional office expansion. For the history of the PTO, we've been an organization that's located in the Washington, D.C., Virginia area. And in the last few years with the AIA, we've now expanded all across the country. And that regional office expansion has allowed us to bring the USPTO services to the people of the country throughout the various regions. And that's allowed us a chance to hire and attract talent from all over the country, people that were not interested in being in DC and wanted to do some work for the government at the PTO. And also to provide a resource to the public in the communities throughout the country to have a local USPTO presence so that you could interact with the PTO and get some answers to questions and and work more closely with the PTO. And as you may be aware, the PTO is a rather large organization. We have approximately 10,000 or so employees, including 9,000 patent examiners, and 600,000 patent applications filed in just 1 year. So we have a lot going on. So the idea of being able to outreach to the different parts of the country is a way to make a large organization smaller and easier to access. So we've added offices in all the regions of the U.S. We have our original office out there in Alexandria. We're here in Dallas. We also have an office in Detroit, Denver, and San Jose. The Dallas office is right downtown on 207 South Houston. I say it's right next to the grassy knoll area. I can look outside my window and see the X where Kennedy met his untimely. We have public facilities in our office, and we're available every day from 8:30 to 5. We are growing still. We have about 110 patent examiners, 13 or so patent judges, and like I said, our office is still growing as we go. And we have a public search facility there for anybody that's looking to do patent or trademark searching and wants access to the same sorts of search facilities and resources that our examiners have. That's available. Excuse me, that's available for you from 9 to 4:30 every day. We also have a hearing room so that you can come and see our proceedings. I know there's been a lot of interest of late in some of our newer proceedings as well as our older ex parte proceedings. So we have a hearing there. You can go and observe if you find out that there is a hearing going on in town. I mean, you have to check with the office to see when we've got something going on. And we also have training rooms and meeting facilities. Another thing that's gone on with the AIA to provide additional access to individuals is the creation of a new entity status. In the history of what's been going on with the PTO, it's always been large entities and small entities. And large entities, of course, had to pay a larger set of fees, and small entities had a reduction in it. And with the AIA, there was the creation of a micro-entity status, which is a status that has an even further reduced fee base so that small entities, individuals, small businesses would have access to the PTO at even lower rates. So that's one more thing to help people be able to access our services with lower rates. And that just shows the form you'd need to fill out.
Okay. Thank you, Stacy. We also have a number of initiatives and opportunities that we provide for inventors and business owners. And so I'm going to go over a couple of the different things that we provide. One of the big things, it came about as a result of the AIA as well, is that we have what we call a Pro Se Assistance Center. We have this for both patents as well as trademarks. We have a 1-800 number in which you can call. As you can see at the bottom, that is a telephone number that you can call. And if you decide to file your patent application pro se, then we will work with you to put together your application and put together the different components. We aren't able to tell you, because we can't give you legal advice, we can't tell you if your patent's going to be patentable. That'll be a determination by our patent examiners and our trade, and then if it can be certified as a trademark registration, we'll do that later on in the process. But we will help you put together your patent application, your trademark application. These pro bono or pro se, assistance programs are actually staffed by former examiners. And so they have now retired, and in their retirement job, they are now assisting inventors and entrepreneurs in the services that we provide. We also have a checklist online for those who are interested in putting together an application by themselves. And we have a checklist of different components that they need to file in order to prepare their patent application. One of the things that I want to point out is that something like this is really important, because what we have found is that 40% of pro se applicants, they have their patent applications abandoned before it even hits the hands of a patent examiner. So things like this, a tool like a Pro Se checklist, our Pro Se Assistance Center is critical to make sure that you have the right things in place, because the things that make them abandon is mostly formalities. They forget to pay a fee, they forget to respond by a certain time period, they forgot to sign their oath or their declaration. So things like that have really kicked them out of the system before it even hits the hands of the examiners. We also have an inventor and entrepreneur resource site which can answer different questions for public applicants and pro se applicants. We also have partnered with different organizations around the country and provide patent pro bono assistance programs. We have volunteer attorneys, and they cover all 50 states, and right now we have had over 700 attorneys join the ranks of pro bono attorneys across the country. And so we have partnered in Texas with TALA, which is the Texas Accountants and Lawyers for the Arts. It's amazing. I never thought we would have accountants and lawyers in the same title. But we work with them, and they provide both patents and trademark services as well as copyright services to applicants, pro bono applicants who qualify. This is a map of the coverage. We do cover all 50 states. Some organizations like TALA actually cover 2 states. So TALA covers both Texas and Louisiana, but we do have at least one organization covering every single state across the country. And here, I know this is an eye chart, but we do have a listing of all the program contacts online, specifically who you need to reach out to if you do have clients or you do know people who are in need of pro bono services. One of the other things that we provide is we actually certify law schools across the country to be able to provide services that are similar to pro bono services. The difference is that the law schools have a little bit more latitude and more flexibility on the clients that they can accept. Pro bono is statutorily limited on the type of clients that they can receive. So you have to be below 300% above the poverty line. So if you are an individual, a single person household, that's around $39,000. If you're above that, you cannot get pro bono services. The law schools are actually not limited by that, and so that's a really important feature. And so the law schools, like the one here, my alma mater, SMU, they do provide law school clinics and students to be able to give clients the ability to come and seek services, legal services. We have also what we call PTRCs, or Patent and Trademark Resource Centers. What these facilities have is that they have a workstation at their library which allows you to search using the same software tools that our patent and trademark examiners use. So it includes East and West as well as TEAS. And so the nice thing about this is that the database that is associated with, for example, East and West, seems to pull a lot more prior art than the typical Google search. We did a comparison, and so when we do a search of the same Boolean terms that we put out there, what we have found is that the prior art that is pulled up using our systems is, you'll pull up twice as much prior art as you would using a typical Google search or internet search. So it's more likely for you to pull the same prior art that our examiners are reviewing using our same systems. So this is a resource that we offer. We have partnered with 81 libraries across the country. As I mentioned, we have assistance centers. This is our pro se assistance centers. These are the hours that they are open and their telephone numbers. Okay, and then I think this is a repeat of the slides before. All right, so I'm just gonna move forward. The last thing is that we do have a patent ombudsman program, and after you file an application with our office, you move from the Pro Se Resource Center into what we call the patent ombudsman. There are times that I realize that for whatever reason, applications are stuck in the system, and you really don't know what is going on, and the prosecution history or the file wrapper is not really giving you a lot of details. If you do have questions, if you're having some difficulties with some examiners in trying to get your application reviewed appropriately, this is the place that you can go. It's another customer service line for us, and you can seek help through the patent ombudsman. Very last thing that I want to point out is that if you do find yourself in a situation in which you are being sued or you would like to enforce your actual patent application, We do have an IP awareness assessment tool as well as a litigation tool. You can go online and find lots and lots and lots of stats on patents that are currently in lawsuits, how many times they've been sued, a number of different statistics that you can use that may be helpful as you're trying to enforce your patent or you are in the middle of a litigation. Okay, so that's all I have.
Mark?
Thanks, Wei Wei. So NASA's funding legislation, the Space Act, we're directed to ensure that any technologies that we create for space and aeronautics also benefit the whole of humanity. So we do that through our strategic plan and implement this through ensuring that we advance our understanding of Earth through the development of technologies that improve the quality of life here on our home planet. So to accomplish this lofty goal, I work together with our scientists and engineers, our technology transfer executives, and our patent attorneys to bring everybody together to strategize what we're going to patent, what we're going to maintain, and what we're going to license and make available to the public. This brings together, we have 10 centers across the country, 20 patent attorneys. Requires close collaboration and lots of phone calls, meetings, face-to-face. 2 weeks ago, we actually met. We gathered all the technology transfer officials and all the NASA patent attorneys in one room and talked through what we're doing, what we want to do. It was the first time we did that, and it was a great and successful meeting, and we've got some good plans for the coming year. Through what we've been working on, we've launched new technology transfer initiatives over the last few years. We're trying to make our technology more available and easy to access and to license. We have a new quick launch licensing. We have a startup license initiative going in which anybody can form a startup company to commercialize a NASA technology, and they're not required to pay any upfront royalties for a while until the company gets going, and royalties won't kick in until they get established. So what we're trying to do is take a strategic and proactive approach to the management of our intellectual property portfolio, and to give non-governmental folks an integrated and seamless way to get into our technology portfolio and make the technologies available to the public.
Okay, great, thank you. I will start off with some questions, and audience, please feel free to raise your hand and let us know if you have questions. So Mark, I'd like to start with you, since you just spoke about NASA's programs and tech transfer initiatives. I'd love to know more about that. So how large is NASA's patent portfolio, and what are some of the technology areas covered by NASA's patents?
So at any given time, we've got about 1,100 active patents. We receive about 1,000 new invention disclosures a year, and then we'll patent, say, about 10% of those. And these inventions are only the inventions that are made by our own civil servants. We also do a lot of contracting and fund R&D to small businesses and large businesses, and those inventions are owned typically by these other businesses. But in any event, like I said, we have about an 1,100 patent portfolio at any given time. And our technologies are what you might think, for example, robotics, propulsion, aeronautics, but the majority of our technology are things like materials, sensors, communications devices, and computer software devices, inventions that are more adaptable to the private sector and not just to make a rocket.
Can you also talk a little bit more about that startup license initiative? That sounds really intriguing. Just a little bit more details.
Sure. So what we've done is we've created a kind of a shorter template for a license agreement. And the requirement is that the company has been in business for less than a year, and that they're interested in taking a specific NASA technology that's been patented, and they want to take that technology and commercialize it. The federal regulations require, before we can license, that there be a solid business commercialization plan. So they've got to provide us a plan for how they're going to do that. And then once, if that looks good, we will let them have it. And then typically, you know, there'll be some sort of an upfront licensing or royalty fee that we would collect. But in this case, we won't do that. We want to give them as much chance as possible to commercialize it and prove it, and then we'll wait and see whether it's fruitful, and then we'll start collecting royalties.
Are all of NASA's patents in the portfolio eligible for this program, or it's only select one subset?
No, any patent that's available for licensing is eligible to.
Okay,
And I'll
fantastic.
point out that even if somebody comes in and is interested in licensing some kind of invention like that, and they don't quite meet the criteria for being a startup, we'll work with them to license on some, you know, mutually acceptable terms.
Okay,
So.
great. All right. Hope and Stacy, you talked a lot about what the USPTO has been doing in terms of outreach. What is the USPTO's view regards to access to women and people of color to the USPTO and technology in general?
Well, I guess I'll start and you can fill in.
Sounds good.
Well, one of the things the USPTO wants to do is to be a leader. If you look at our workforce is very diverse. We have thousands of women and people of color all throughout the USPTO and at all levels of leadership. About 35% of our workforce are women and people of color, and are people of color, and about 31% of our leadership is female. So we can serve first and foremost as an example that a workforce and a leadership that looks like America is a workforce and a leadership that can access all of the various talent pools of America. So that's one thing that we do, is we provide an example of a diverse workforce working in the technology field. And we provide a lot of information about that. We put a lot of brochures and other informational things out there so that people can see a diverse workforce in intellectual property. We also support a number of initiatives. We work with groups such as the Girl Scouts, Girls Who Code, High Tech, High Heels, all sorts of places to really encourage the pipeline of women, girls, and people of color to get into science and technology, to have access to this field that's ever growing and touching all parts of our economy.
Yeah, in my office, in the Texas Regional Office, actually, we have an extremely diverse workforce. In the leadership ranks within my office alone, we have 40% of the leadership is female, and 100% of the leadership is actually minority. So this is a really big deal to the USPTO. We want to be a leader and an example. As Stacey mentioned, we want to encourage women and minorities to go into a STEM career, to pursue STEM technology and innovation and entrepreneurs. One of the things that we are concerned with is the number of women who are actually listed on patents. We've noticed that a recent study shows that only 18% of all the patent applications, or patents, excuse me, that are out there have a female listed on the patents. That's an extremely low number, and it affects who is actually going to be successful at the end of the day with funding. What we do know is that venture capitalists as well as angel funds view that patents as one of the major reasons in which they want to fund a particular organization or entrepreneurship or a business. And with only 18% having females listed on that, that's already putting females at a distinct disadvantage. So as a result, we are putting on different programs like women's symposiums. We have programs like All in STEM, and we work with the Girl Scouts. We do different things that are out there to help promote women and entrepreneurs and girls to get into the STEM field as well as become entrepreneurs.
And the USPTO has been voted the best place to work in government, among government agencies. Is that right? Am I saying it right?
Yes, a few years ago, except NASA took over that last year.
Well, we have representatives from both,
Two of
so
the best agencies are up there, yeah.
fantastic.
For now.
So there's a little bit of a conflict between patent monopolies and economic opportunity. I have to be honest, as a patent attorney and been in this field for a long time, I've not given it too much thought on that, but what is the USPTO's view on that?
Well, you have to look at patents not just as something that's a monopoly, but also a way for a small business or an individual to break into an industry where they might otherwise be facing closed doors. So giving an individual a patent right can put them in a position where they can get a seat at a table that they would not have otherwise had. So yes, patents do in a way disrupt what is thought of as the typical free market economy, but that disruption is a powerful thing that can be a useful thing for small businesses, individuals, people who have an idea, you could say sort of a dollar and a dream, and they have a way now to get into the conversation and to be a power in that conversation. Because otherwise, if you just have an idea and you don't have any way to protect it, what's going to stop the major players from just seeing what you're doing, taking what you're doing and just running off with it and leaving you sort of powerless and not able to even break into the industry? So yes, patents do sort of disrupt what you think of as the free market economy and do give some people some sort of monopoly power, but they also empower individuals at the same time.
And let me add to that a little bit. We recently received some numbers on the impact of IP on the economy. We know that IP-intensive industries directly account for 27.9 million jobs in 2014, which is up almost 1 million jobs from 2010. We know that IP industries account for $6.6 trillion in value in 2014. In 2014, we also know that workers with IP-intensive industries earned an average weekly wage of, wow, there's a lot of commas on this. I think it's going to be, well, anyways, they earned
A lot.
because it looks like it's millions of percentages higher, but I don't think that that's right. Earned $896 on average per week more on their job in wages. And then revenue specific to the licensing of IP rights totaled $115.2 billion in 2012. So while we're talking about the fact that, patents do convey a monopoly for a certain period of time, what we do know and what we do realize is that patents and IP and technology not only gives you a seat at the table, but it's moving you forward. It moves you into a position that gives you more access, more growth, more wealth, and it adds to the economy overall.
And if I could just add to that, that kind of fits in with how we decide to patent our technologies. It's a tough decision, and it's based on whether we think the invention can be commercialized and attract a licensee, a commercial licensee to take the technology to the next level. And without the patent, we're not going to, you don't get that next step.
So that's a good segue to my question about how NASA decides what to patent, what not to patent, what to keep as trade secret. What are all the factors that are considered when you're making that decision? And how is that decision made? You convened.
So we have the patent attorneys, first of all, will decide whether something is actually patentable. And then the next step would be to decide whether we should patent it. And that's when we get the tech transfer people in the room and do an analysis, a market analysis, a commercialization analysis, and try to determine whether exists a market to get a license. We don't do trade. We're the government. So there's no trade secrets. We try to disseminate everything in one way or another. And then once we do patent, then we've got to be strategic on what we keep and maintain. Patent fees are significant. We have a limited budget, and the patent office charges us full freight, just like we're not a micro
It
entity.
seems like they should get a discount.
Thank you. Yeah, so
Especially the ones that they're licensing out, not getting any reimbursements.
so what we'll do is we'll typically pay the first maintenance fee as a default after 4 years, but then by the 8th year, if the patent is not subject of a license, then we'll let it go, and then definitely by the 8th year for the third maintenance fee. We have a chart that just shows the dramatic drop off of what we maintain. Our maintenance fees actually are about 50% of our patenting budget. They're very significant. So.
Going back, Hope, some of the statistics, stats that you talked about patent-intensive industries. What is included in those industries? Do you know?
It's going to cover the gamut, and so it'll cover
Pharmaceuticals.
So like within Texas, the areas that receive the most patents are oil and gas, well technology, and the refineries and polychemicals that are associated with that. Within the Dallas region, it also includes semiconductors, and that's a huge factor that is here, and business processes. So within Texas, those are probably what I would consider from a patent grant standpoint, the IP-intensive industries.
Okay. And Professor Manel also mentioned and talked about software as a patent eligible, or whether software should be a patent eligible subject matter. And as a patent practitioner that's been doing it for a long time, I've seen it swing both ways. And so what is I know we're as a collective group, we're all kind of struggling with clearing this 101 hurdle when we're prosecuting patent applications, as well as in post-grant reviews. And the Patent Office in my view, has tried to be very helpful in terms of issuing guidelines. So what is the USPTO's view of this development in this area, and do you see any changes down the road to this seemingly obstruction to patenting software? And as a patent attorney that works with a lot of inventors in this area, it's become very frustrating not being able to tell my clients, give them more definite answers as to whether something they're working on, that they're investing funds and money and energy into, can be protected with a patent. Their investors still demand patent protection, but the outcome is very uncertain at this point.
Well, I'd say that the Federal Circuit has made it clear that there's no per se bar to patentability of software. And one of the things that we do in the PTAB is we take a lot of time to make sure that the patents that are before us have met the guidelines put out in the Alice decision. And I know that there's a lot of controversy about Alice, to put it mildly, but that's what we are guided by, and we have to look to those cases in that line to get all the guidance we can as far as what we can define as patentable and what is not. So there is no per se bar. It is a time where I think that there's a lot of energy into figuring out where the boundaries are, But I think the more guidance we get, the more cases we do, I think it's becoming clearer with time. And if I was going to say anything to the practitioners out there as far as trying to keep your things to the side of patentability, clarity is your friend. Anything you can do to provide clarity as to what was actually invented and to be clear about what the new thing is in your patent, I think is good. And that helps you to be more rooted in the things that are patentable, to focus on the clarity of your invention, I think.
And let me just add to that a minute. And so, believe me, I mean, not only is Alice frustrating to the practitioners, it is just as frustrating to the USPTO, as we are trying to also put together guidelines, especially for our examiners. Our examiners struggle, believe it or not, with this concept as well. And you know, we believe that, obviously, I mean, as Stacy said, I mean, there is no per se bar to getting a software patented. So, but is it going to be more difficult now? The answer is yes. And there is going to take a little bit more work to do that. From the examiner's standpoint, to the extent that you can make your claims as close as possible to the examples that are provided by the MPEP, that makes their job easier. If you can relate it to the MPEP examples and how they are similar, then that helps them from a guidance standpoint. So there is no per se bar. It is more difficult, but it is still possible to get software patents from our office.
Mark, does NASA?
Well, I'll just say that once, because of Alice, we've had to be more critical in figuring out the software patents we're gonna try to prosecute. I will say that our technology transfer executive doesn't want us to patent any software. And that's not realistic either. So we have a tension, which is probably a good tension to have right now, and because it's forcing us to really examine and try to patent only that software that makes the most sense in light of our strategy.
Do we have any questions from the audience? There's one back there.
Follow-up to that, I'm wondering if you're aware if the PTO is planning on putting out any updates on one-on-one guidance in light of the Peru and the AFCO decision that just came out.
So we're in the process of actually putting together road tours. It's not really a road tour, but we're going to be having roundtables on subject matter eligibility just in general. So I'm sure that it's going to include cases that have recently come out and different things on that. But we are trying to get more clarity on subject matter eligibility just in general. And so you will probably be seeing several FR notices as well as I mentioned, the road tours that are going to be coming to town. So I encourage you to actively participate in that, because the translation of that will be additional guidance that results from that.
So that would be done locally here in Dallas?
Right, so we are in the process of scheduling. I just got an email yesterday, so this is hot off the presses, that we are probably going to be doing a roundtable in December in our office.
Yes, right here.
I was just curious about the statistics you mentioned earlier. You said the leadership in the Texas office is 100% minority.
Yes.
That sounds rather extreme to me. That means what?
Is that just you?
No. Yeah, that would be great. I am 100%. No, our management team, our leadership team is made up of 5 individuals, and all 5 of them are minority. We have 1 Hispanic, 3 Asian, and 1 African American. So that is that's our office composition.
So my follow-up to that is that like the white folks have no further interest in
No.
No, that's not the case. That's not the case. I mean, I don't know how my office was so fortunate to have all minorities, but it just so happened that that was the situation that resulted for the Texas regional office. Now, not all the regional offices has the composition that we do. So the Silicon Valley office, John Kubeka, he is Caucasian, and so he is the regional director that is out there. And so obviously his statistics are going to be slightly different. But it just so happens that in my office that's the situation.
And it seems like Dallas has started out that way, and when Dallas started, there were only 4 judges in Dallas. It was a 100% female office. So we used to joke that Dallas was the ladies' office. We have since been outnumbered by the men, but it's just the process of hiring, and as we said, going around the country gives you a chance to access different talent pools. Accessing more talent pools gives you an opportunity to get an even more diverse workforce that looks even more like America.
Well, and Texas is a majority minority state already. So it's not surprising that, our office is reflecting more of a minority status.
How many PTAB judges do we have now
13.
in the Dallas office?
13. The reason I'm thinking more than that is that we have a couple judges that are on a program where they are not officially in the office, but they have different duty stations throughout the Texas region. So there's
So 13
in-
associated with Dallas, but 17 that
Altogether.
altogether, if you include our hotelers. Yeah.
Yes.
I have a question for Mark. What would your role be, or what would your role have been in relation to extradition cases involving persons who have hacked NASA databases? The Gary McKinnon case 20 years ago, or the recent case, the Love case, that's quite popular.
Yeah, for my job, I don't have a role in that. That's handled by our security office, the Office of Counterintelligence.
Yes, right there.
Has the United States government ever brought a patent infringement case against a private entity?
It doesn't happen very often, and so the Department of Justice is our lawyer. We'd have to make a pretty good case to get them to take a case on in light of what their overall caseload is. We do have patent infringement cases that have been brought against us and that we defend, but we don't sue very often.
Yes, back there.
I have a question regarding microentities and compact prosecution. I was wondering, first of all, what metrics you guys use in order to evaluate whether or not prosecution is moving efficiently and in a compact fashion. And secondly, I was wondering what type of metrics are applied to the pre-appeal brief process, as I have an extreme example in which I sent in a response to non-final, a response to final, a pre-appeal brief, and then an appeal brief. And finally, only on the petition to the director did the director agree that we never received an actual first rejection. And they had to go all the way back to non-final. And if that was a micro entity, that would have been a lot of attorney's fees due to the prosecution not being efficient and compact. So I was wondering if you evaluated that as to the micro entity status and what type of measurements you're using to make sure that we are receiving compact prosecution.
So microentity status gives you the ability to have reduced fees. And I do realize that as a microentity and as an independent inventor or a small entrepreneur, speed is going to be extremely important. But the fact that you are a microentity status does not determine how fast your prosecution is going to go, unfortunately. We do have compact prosecution, and we do have a number of measures that our examiners are measured against, including the length of time, the amount of time that they take to review and prepare an office action, appeals, appeals is before PTAB, but different things that are associated with that. So there are measures based on, sometimes their GS level. They are expected to do turnaround on certain times within a certain time frame. So there are measures that are associated, and it's all time-based. It's almost like a law firm, and so they're given a certain amount of time to be able to do something in a period of time, and they are rated against that on how efficiently that they do manage their docket, how quickly they get through their docket. They are measured against that.
So it's not outcome-based. So in the case of my examiner, in which we had a pre-appeal brief with his supervisor, and eventually the director was the one that said, hey, they never received an actual first rejection, that outcome wouldn't in any way be counted against that measure?
Not that I know of.
And keep in mind, for microentities and small businesses and the like, there are also resources to help people as they make their way through the office. The Patent Ombudsman's Office is one that we like to bring up as a way that you can have somebody to help you get through the process, because we know that patenting, for someone who doesn't know the process and who's not used to it, it can be somewhat overwhelming to deal with the PTO and to work your way through the patenting process.
Yes, back there. Yes, go ahead. Yes.
Does NASA
Oh.
apply for patents internationally, or does sovereign immunity bar?
No, we can apply for patents internationally. We don't do it very often. It's expensive, so, to say the least. So maybe one or two a year, but for the most part, but we can do it. There's no reason.
Is there outer space jurisdiction for patents?
If the U.S. government came up with, or some scientists at NASA came up with a method of capturing electricity from the atmosphere or something like that, you could pretty much take over the energy space worldwide. And so, it seems like that would be something within NASA's purview.
Well, we would look at it as in light of our strategy, and that may not be something we'd want to patent. We maybe just want to give that away. So.
Yes, back there. Yes, you have your hand up.
My main interest is in copyright. I'm just curious what kind of interactions PTO might have with the Copyright Office. For instance, I can imagine that there may be common interest in international piracy with the suit to the U.S. Trade Representative. Of course, software is subject to patent and copyright protection. So I'm just curious, how your offices interact.
So copyrights, the Copyright Office is a separate entity, so we don't process any of the copyright registrations in and of itself. But the Copyright Office does not have a policy arm. So when it comes to different policies, different legislation that is before Congress, or different things that are going to be discussed before the president, our Undersecretary Michelle Lee is a representative for all things IP. Our office does also have an international arm, and under that international arm, we do have someone that specializes in copyright that goes out and discusses DCMA and different legislation around the world. And so we are negotiating those treaties as well as the legislations around the world associated with copyrights.
Yes.
Yes, I have a couple of questions. First of all, Director Shimabukuro. She knows I'm a paralegal. In what ways can paralegals get involved, if possible, in the Pro Se program, and what can they do as far as being proactive in that program?
Are you talking about actually working with the Pro Se program, or
Volunteer.
volunteer for the Pro Se program?
Volunteer.
So for the Pro Se program, that is fully staffed actually by the USPTO. So if you are a paralegal that works for us, then you can probably get involved in that way. Although my understanding is that the majority of the people there are, as I said, are former patent examiners, so or trademark examiners. And so, but I can check into that if that is something that you are interested in and you would like to come and work for us. I can check into that.
We can talk.
Okay.
You had another question?
The other question I have is directed towards Judge White. With the openness of the Patent Office in general, have you seen how that has impacted over the 3 years as far as what comes across your desk for review? And also, what issue is it that you see the most at this time as far as confusion is concerned, where we need clarification from the PTAB?
Okay, how have things changed in the years that I've been at the PTAB? I have been in several different roles as far as judging cases. I've moved from ex parte cases, the re-exam cases, now into AIA cases. And I say, over the years as I've moved along, I've seen an increased sophistication in the work that's coming from the bar. There's been a lot of change with the AIA, and over the years, I think the practitioners have really gotten their hands around it. So now we're getting some very sophisticated and difficult arguments coming to us. I don't think you guys know how much time we spend going back and forth over the issues raised in your cases. So we appreciate the legal work that we're seeing because, like I said, you guys are keeping us on our toes. As far as an issue that has caused confusion in the bar, I think that there's a variety of things that are going on. Alice issues, of course, are very difficult, and there's a lot going on as far as people trying to figure out the boundaries of 101 jurisprudence right now. So I think that that's an area where every Federal Circuit case, I know we read it with great interest, trying to make sure that we understand the boundaries of what's going on with 101 at any given time. And as far as procedurally with things that are going on at the PTAB, I think that folks are just getting used to how active we are as a bench. I think that people are not used to a set of judges that are going to get in there and start asking you questions about things that are in the code. I know judges that will sit there and start drawing carbon chains. That's not, I'm a computer science person, so that's not really my lane, but I think that people are getting used to that with us, and they're realizing that when you come to a hearing before us, you have to come ready to play, and you don't know exactly what we're going to ask you about, and you have to be ready with everything in your record and deal with whatever comes at you.
Okay. As we are near the end of our time, so we will just wrap up, and thank you so much for your time today. We really appreciate you sharing your insights with us.
Thank you.
Thank you.